Dr. Shield, and we do insurance differently than most companies. Things like simplifying details so it's easy to understand what makes us Malaysia's most innovative indemnity provider. As a Dr. Shield client, you'll enjoy comprehensive coverage with fewer exclusions. With some insurers, you'll only find out what's not covered when you make a claim. Our policy details are online and easy for everyone to understand. Competitive premiums that don't keep increasing. Many insurers increase their premiums across the board to compensate for losses. Dr. Shield limits the number of doctors insured from high-risk categories, so our premiums start fair and stay fair. Prompt dispute resolutions. We're pro-mediation because settlement and negotiation, instead of endless litigation, is better for everyone. Career and reputation protection. Typically, litigation can drain a doctor financially and emotionally. We limit the damage by both, so our clients emerge good names intact. And peace of mind, because a happy doctor is a good doctor. Our different approach to creating policies means we put you first, before us, so you can enjoy your career and sleep like a baby, even if you've just delivered one. Dr. Shield, insurance with a difference.
Hello, hi, and welcome to another of our medical legal webinars. And tonight, the topic is relevance and importance of expert evidence in medical negligence cases. Okay, this event is you'll be eligible for CPD, and I'll go through the details later. But first, our participants, our panelists, let me introduce them. This is Felix Raj. Now, Felix obtained his bachelor's degree in law from University of London in 1992 and subsequently the master's in insurance law in 2000. He's been in practice for over 29 years now, commencing at Shern Delamore and Company. He's a founding partner and sole proprietor of Felix Raj Chambers. He specializes in medical malpractice, and he has been appointed to act for numerous doctors and hospitals and successfully defended a number of claims. Okay, he's contributed to the Malaysian High Court practice printed by the Malaysian Law Journal and Handbook. He's currently a member of the investigating tribunal panel of the Advocates and Solicitors Disciplinary Board. The other member of the panelists is his senior associate, Joseph Lam, who was called to the bar in 2014. Joseph began his career primarily in banking, tenancy disputes, anti-money laundering matters, etc. His exposure and experience grew to cover corporate dispute, boardroom tussles, and mandatory general offer pursuant to the Capital Markets and Services Act 2000. And he has assisted senior counsels in appellate courts. And the third member of our panel today is Encik Ahmad Isaac, who graduated from the University of Technology Mara in Shah Alam, and he was admitted as an advocate and solicitor in 2012, beginning his legal practice at Shern Delamore, after which he joins Mr. Sheikh David Raj until 2017, when he joined Felix Raj Chambers. And throughout his legal practice, he has been exposed to multiple areas of law, including medical, legal, insurance, contract, construction, land acquisition, environmental, and banking. So that's the introduction for the three members of our panel. Just some housekeeping slides. Doctors who are watching this, and after the live stream and after the Q&A, we'll display a QR code at the end of the talk. This code will be active for 1 hour only, after which it will no longer be valid. But you can still claim CPD points by logging in to our CME module and answer some MCQs. The link to the CPD module is at the bottom of the page. For the doctors, this link, there's a bit of delay. It will be available only after tomorrow onwards. So apologies for the delay, but due to a technical glitch, only tomorrow. So, but for tonight, if you're watching live, you can claim through by scanning the QR code. For dentists, you've been provided with a link to register for CPD points. If you have not, please click on the one below the doctors there on the main page. And for Q&A, we prefer if you join us on Slido. And if you have the app or you go to the slido.com website, you enter 4912682 to join the session. Or if you can scan the code, it will take you directly to the Slido session for today. All right. Now, you can also ask questions if you're watching directly on YouTube. Okay. And we will post your questions as they come up. All right. Now, without further ado, let me start the lecture, which is a recorded lecture. So we'll be streaming the live recording. Okay, so here we go.
Hi, good evening. I'm Joseph Lam. I'm the Senior Legal Associate of Mrs. Felix Raj Chambers, and we regularly act for private hospitals as well as doctors in medical negligence claims that are regularly filed in court. With me this evening is Mr. Isaac, who is also a partner of the firm. In today's topic, we will share with you the roles and functions of an expert witness in court and why are they important in defending a claim that is brought against doctors. We have broken up the topic into 4 segments. The first 2 will be why appoint medical experts, what is the role and scope of expert witness. Point 3, do all cases require expert evidence? And point 4, how much does the court rely on expert evidence? I will be presenting points 1 and 2, while Encik Ahmad Isaac will be presenting points 3 and 4. Thereafter, at the end of the talk, we will take your questions and we will answer your questions. Without further ado, let us proceed. Here, expert witness. Why appoint medical experts? In a medical negligence claim, it falls under the tort of negligence, whereby the patient will have to prove, among others, the duty of care, the breach of the duty, and the quantum of damages. In respect of duty of care, it is undeniable that doctors owe a duty of care to patients. The next question is, what is the standard of care? So, as you all know, as doctors, you are judged by your peers. So therefore, it is important that medical experts are called to determine whether the standard of care that was given by the doctor was appropriate or not. So hence, in this slide, many medical malpractice claims depend on medical expert explaining what are the accepted standard medical practice that was required for the patient with a given condition or presenting symptoms and history. Next slide. The medical expert will need to explain whether the treatment afforded to the patient by the doctor meets such accepted standards and such accepted and standard medical practice. One of the many duties of a medical expert is to explain complicated and technical subjects in a manner that judges and lawyers, we are not medically trained, would understand, given that neither of us have any medical background. So, for example, if you are an orthopedic consultant and the patient then files a medical negligence claim against you, the patient will call a doctor in the area of orthopedics to provide his or her views with regards to the treatment and care that was accorded by you. The patient cannot call another expert in another area of specialty, say cardiology, to comment on the orthopedic surgery that was conducted. Likewise, as doctors in defending the claim, you too are entitled to call an expert in the same field to provide his or her views in regards to the treatment and whether such standards are met. One of the cases that we'd like to share with you is the case of Pyramelu against Dr. Amarjit 4. In this case, the plaintiff filed a civil claim in the Sessions Court against 2 eye specialists, the Director of Hospital Typing and the Government of Malaysia, in claiming for medical negligence. During the trial, unfortunately, the plaintiff was the only witness and did not call any medical expert to give evidence. In the end, the judge dismissed the plaintiff claim and the plaintiff appealed to the High Court. At the High Court, this is what the judge said. At the High Court, V.T. Singham underlined the significance of an expert witness in a medical negligence claim. This court is of the view that it's important for the plaintiff to have adduced medical or expert evidence to support the allegations contained in the statement of claim against the defendants, and this could have also assisted the court or thrown some light in arriving at its decision. But unfortunately, there was no such evidence before the trial court. In the instant appeal, this court is of the view that the testimony of a medical expert would have been most material to the issue of causation. But unfortunately, the patient opted not to call such evidence. Eventually, the High Court dismissed the patient's appeal. We will now evaluate some live cases. That were determined by the courts. That was in slide 7. We'll now move to the next slide. Here, I'd like to share with you some legislation which provides the requirement of an expert. Section 45 of the Evidence Act provides that when a court has to form an opinion upon a point of law, of foreign law, or science or art, the judge would need an expert. And such expert is to guide the courts. We'll give you a case scenario. A patient came in with a certain symptoms, and based on the history taken by the doctor and the presenting symptoms, the doctor ordered test A. The results provide that there are no medical conditions that require such treatment. As such, the doctor advised the patient that he does not require any medical intervention. However, subsequently later, the patient had cancer, and the cancer remained undetected for many months. After having first consulted the doctor, the patient subsequently consulted another doctor after his condition had worsened, and the patient was then informed that the cancer was untreatable. The patient then lived on while a little longer in severe pain. So here, now, if you call an expert, the first expert that you have to call is the oncologist, an expert in the area of oncology, to give evidence, among others, whether given the history of the patient, the presenting symptoms, and the outcome of test A, and relying on medical literature, the need to undertake further investigations. For example, whether the doctor should order more sensitive tests to rule out the possibility of cancer. Or whether given the history of the patient, the presenting symptoms, and the outcome of test A, and relying on medical literature, the doctor had acted reasonably in the circumstances and in accordance with accepted and standard medical practice, whether such practice is correct or not in not ordering for the test. As judges, again, we emphasize that we do not have such specialized knowledge. So hence, we are unable to determine whether the particular oncologist has met the standard of care. So hence, we need an expert. The patient may have shown a slow-growing cancer, and the same would not have been detected by the first doctor at the material time when he undertook the first test. Hence, the non-diagnosis of cancer is not due to his error or failure, thereby exonerating the doctor from any negligence. This would have to come from the evidence of an independent medical expert. It cannot come from your own evidence. It cannot come from your lawyers. It has to come from your expert evidence to submit before the judge to determine whether the standard of care has been met or not. Next, it must be noted that a medical expert may be asked of different questions, a set of questions, and a set of acceptable standards on what could have been afforded to the patient based on the presenting circumstances. The expert may ask of possible alternatives during direct testimony or cross-examination to consider various permutations before arriving at his conclusion. Subject to the evidence adduced by both parties, that means the patient as well as from yourself, including of evidence of medical experts, the judge then has to determine and evaluate the evidence whether the conduct of the doctor meets the acceptable and standard medical practice, and whether the actions or conduct of the doctor concerned amount to medical negligence. Next. So then, what is the role of an expert? As we have said earlier, the role of an expert is to guide the courts. Order 48, Rule 2 of the Rules of Court. This is the Rules of Court. It provides that the duty of the expert is to assist the court on matters within his expertise. And secondly, his duty overrides any obligations to the person whom he has received instructions or by whom he is paid. In short, basically, the expert has to be independent regardless of who he was appointed or who he was paid to attend court. So your expert cannot provide an opinion that is only favorable to you. the expert has to give an independent expert view of all of the circumstances based on the documents that were made available. The MMC also provide a guideline. We would like to emphasize point 8, 9, 10. Point 8, a registered medical practitioner is qualified to testify as an expert witness if he has special knowledge, skill, experience, training, or education sufficient to qualify him as an expert on the subject to which his testimony relates. Such special knowledge, skill, experience, training, or education must be shown before the witness may testify as an expert. Point 9, an expert's special knowledge, skill, experience, training, or education may be shown by admissible evidence, including his own testimony. And point 10, expert witness may be appointed by any party in legal proceedings or disciplinary inquiry. This means that you, in the event you are brought into an MMC complaint, you may be able to call an expert in defending the complaint against the patient. In summary, upon the appointment of the medical expert, whether for the patient or the doctor or hospital, the expert have to undertake the following steps. These are a few suggestions that we may put forth. We have 7 suggestions. First one is to undertake a thorough review and study the medical reports, including the results of any investigations and surgical procedures undertaken. 2, prepare a comprehensive report and identify the facts that they rely upon. Provide your response on the diagnosis, advice, treatment, and care given to the patient, including advice given to the patient by the doctor when taking informed consent. In the expert report, the expert has to undertake a review and analysis of actions taken by doctor and determine if such actions are in accordance with the required medical standard of care. For the patient, the expert for the patient will state, among others, the shortcomings, the errors, the failure of the doctor to act according to the required standards of care, and whether such a deviation had resulted in the injury by the patient. For yourself, the medical expert in defending you will state, among others, that the actions of the doctor, given the circumstances, were in accordance with acceptable medical standards, and hence your actions or conduct is acceptable. 6, which what we have said earlier, medical expert will acknowledge that their duty is to assist the court and not the party that's appointed them. In other words, they must be independent. 7, medical experts must support their views, their opinion based on medical literature. Any evidence that is not supported by literature, highly likely the courts will not accept such evidence. Then the next question, what is the scope of the medical expert in giving his opinion? Here, unless the medical expert of certain specialty has qualification or experience, such expert ought to render his opinion within his specialty. For example, if obstetric and gynecology expert is rendering his opinion, he should keep his opinion within his confines of his specialty, and he is not allowed to comment on another specialty of, for example, an orthopedic surgeon. A good example that we have conducted, this is a case of Ahmad Zubey and against Dr. Zainal. This case started at the High Court, went up to Court of Appeal, and went to the Federal Court. This is the case that we acted for the hospital. In this case, the husband of the deceased patient filed a claim against the consultant cardiologist, a senior MO, Pantai Hospital KL, IJN. In support of his claim, the husband called 3 experts: consultant cardiologist, consultant ONG, and consultant anesthesiologist. After full trial, upon considering the expert witness, the judge dismissed the husband's claim, and not only dismissed the husband's claim, the judge criticized the experts, which is the consultant ONG and consultant anesthesiologist. This is what the High Court said. It is the observation of this court that while the experts may agree on some of the peripheral issues, they were basically divided on major issues. Among all the witnesses who gave evidence in this court, the court found that the opinion of SP5, which is the plaintiff witness 5, to be least acceptable. She was forced to make numerous retractions and overall did not create a favorable impression in the witness box during cross-examination. It is also the observation of the court that we had experts in a particular field, i.e. the 4th plaintiff witness and the 5th plaintiff witness giving their views in the field of cardiology, of which they are not professed experts, and as such, this court has to be circumspect in regard to the expert evidence presented to it. So all in all, in short, when you are called to give evidence as an expert witness, it is strongly, highly advised that you keep your expert within your expert views within the confines of your specialty and not to deviate to any other area. For example, as I've said earlier, if your area is in orthopedics, just keep your report within the confines of the area of orthopedics. Do not venture out into any other area which you do not have specialty in. Because if you do, the judge, if you do any cross-examination, this comes out, the judge will not accept your opinion. Yeah. Okay. Yeah, and then I stop here. Yeah, and I'll pass the time now to my colleague, Ahmad Isaac, to proceed with point 3 and point 4.
Hello everyone, my name is Ahmad Isaac. I'm also a solicitor from Felix Raj Chambers, Joseph colleague. I'll be presenting on 2 points. The first point is, do all medical malpractice cases involve medical expert witnesses? Now, as important as an expert witness can be, the short answer to this question is no, not all medical malpractice cases require the expertise of expert witnesses. Because, okay, if I were to give examples, is where these cases are centered on factual disputes, where only factual evidence are required. Now, why can't you call, expert witnesses to give factual evidence? This is because as an expert witness, they are not factual witnesses, hence they cannot give factual evidence, and vice versa. A factual witness who is a person who has been involved in a case, for example, the treating doctor or the patient or the nurses or the hospitals, these people will have been involved in the treatment and management of the patient, hence, as they cannot give expert evidence in court, right? Now, what are the examples? The first example, this is actually based on a real case, is where the issue is whether a surgeon left a surgical gauze or swab inside of a patient during a surgery and then forgotten to take it out. Now, the problem is, as explained by Joseph earlier, when we appoint expert witnesses, the first thing that we will do is, we will prepare a copy of the medical records. And if the matter has escalated to a court action, we will also give a copy of the pleadings, the statement of claim, the defenses, and perhaps statements made by the patient and statements made by the doctors. However, when the expert prepares his expert report, he is limited to the information and documents that are given to him. Like, for example, this case regarding the surgical gauze. An expert can look at the clinical notes. He can look at the operation record. But ultimately, that expert is not in a position to say or to make a determination, oh, this doctor left the gauze inside the patient, or the other way around. He cannot give such factual statement. In a situation where it's a factual dispute requiring factual evidence, it is for the court to decide without the assistance of expert witnesses. Another example is a case where the issue is whether a doctor had given advice or sufficient advice on the risks and procedures before the surgery was undertaken, right? The same thing. The expert has the medical records, has the pleadings, the statement of claim, the defenses, the statements made by the doctor and the statements made by the patient. But ultimately, that expert is still not in a position to say, oh, this doctor had advised the ways and procedures before the surgery was undertaken. Because most of the time, what we have is that, like for example, the consent form, or signed by the patient and the operating surgeon, where, for example, in a column where what were the risks explained, the doctor will write there bleeding or infection. Now, the question is whether the issue of bleeding or infection was sufficiently advised to the patient. The expert, when reading the consent form or the clinical notes, wouldn't know whether such explanation was given or how sufficient the explanation was given. Again, in a factual dispute where only factual evidence is required, the court will make the determination. Some experts have tried, whether they are instructed by the patient solicitor or the doctor solicitor. Some have tried, to give factual evidence, but when they are being cross-examined by the opposing lawyers, the expert evidence will fall down. Because he is not in a position to make a factual statement. Now, and also I can give a third example. If a surgeon operates on the wrong side or on the wrong leg, for example, that is simply a straightforward matter which does not require expert evidence. Most of the times, cases like this, we try to resolve well, before the full trial. Okay, now I will now move on to the next point. How much does the court rely on expert evidence? Okay, by law, if in cases where expert evidence are required, is where the issue is it's a foreign law or a science or art, where the court will need the assistance of expert. Because as explained by my colleague Joseph earlier, we the lawyers and the court, we are, when it comes to medical, when it comes to medicine and we are simply lay person. We have no idea, like for example, an issue whether the doctor should have undertaken a conservative treatment or invasive surgery. We have no idea. Hence why we will, in cases like that, we will try to find expert to give expert opinion on whether or not, for example, conservative treatment or invasive surgery. But before I move on to the next slide, the reality is that appointing expert witnesses can be expensive, and I've had cases where the patient or the patient's family, they did not appoint expert witnesses. It's either they choose not to, or they simply cannot afford it. But even if that is the case, which was the case in the cases that I have experienced, when the court has to decide, on an issue which is beyond his knowledge, beyond his expertise, he will not be able to make a decision at least in favor of the patient, without an expert opinion. One of the example that I have is in the case of Abdul Razak, where the court held that it is well settled that the plaintiff bears the burden of proof in cases of this nature. It is the plaintiff's burden to prove negligence against the defendants on the basis that what was done was a reasonably competent practitioner skilled in that particular art would have done or would not have done. Basically, okay, because one thing that we all have to remember is that whether, in a medical negligence claim, mostly comments by the patient or the patient's family against the hospital or the doctors, they as the claiming party bears the burden of proof. It's their case, they have to adduce the evidence, they have to call the relevant witnesses, they have to discharge that burden of proof in order for their claim to succeed. Mostly in medical negligence cases, they have to call expert witnesses. They have to call medical specialists. Another example that I like to highlight is, in the case of that was highlighted by my colleague Joseph earlier, is the case of Perimelu Virapan against Dr. Amijit Kaur. Now, in this case, the court underlined the significance of expert evidence in a medical negligence case. And I like to just read out what the court has said. This court is of the view that it was important for the plaintiff to have adduced medical or expert evidence to support the allegations contained in the statement of claim against the defendants, and this could have also assisted the court. Now, this is the key word, assisted the court or thrown some light in arriving at its decision. But unfortunately, there was no such evidence before the trial court. In the appeal, this court is of the view that the testimony of a medical expert would have been most material to the issue of causation, but unfortunately, the plaintiff opted not to call such evidence. So, back to the question, how much does the court rely on expert evidence? How much is quite significant. The presence and the assistance of expert witnesses, especially in medical negligence cases. Hold on a second. Especially so for the claiming party. In the context of medical negligence cases, it would be the patient or the patient's family. I've had cases, or rather, I have at least one case where the claiming party, the patient, have called expert witnesses, and none of the defending parties, the defendants, i.e. the hospital and the doctor, they did not call any expert witness. It's very rare, but in that case, the court dismissed the claim. So now it just highlights my point earlier that expert evidence or expert witnesses, their presence and their assistance are required and necessary, even more so for the claiming party. Thank you.
Okay, that's the end of the streamed talk. I hope you guys have learned something. I'd like to invite the panelists to come online to the stage. First off is Felix Raj. Welcome, Felix.
Hi, good
And
evening.
yeah, and Isaac. Hi, Isaac.
Hello.
Yeah, and last but not least, Joseph Lam. Hi, Joseph.
Hello. Hi, doctor.
So, first of all, while I'm just checking to see if anybody has asked questions, and it must have been crystal clear because nobody has asked any questions so far. Um,
Oh, we scared everybody, doc.
I don't know. Lawyers, I mean, doctors are always scared of lawyers, you know.
I mean, look, if I can, just at the onset, just thank you very much for organizing this webinar together with Jay Ashwa and Dr. Sheel, right? And also, thank you to my partner, Chamat Isaac, right? And my senior associate, Mr. Joseph Lam, for their presentation. And yes, now we are available for questions to be asked as regards Isaac and Joseph's presentation.
Maybe I can start the ball rolling.
Yeah.
I mean, who qualifies as an expert? Is there some minimum criteria, or you just pick and choose somebody who is a consultant
Well, I
or
mean,
specialist? I mean, is there like a minimum number of years, or what do lawyers look for in
well,
expert
I think,
witness?
yeah, I think what lawyers, if I may jump in here, what lawyers would look at in engaging an expert is very simply somebody who's well experienced in that specialty or subspecialty, right? And somebody who has, for example, given evidence previously, right? And that evidence has been accepted by court. You see? So that would be, I would say, two critical criteria, apart from the fact as to whether, putting aside whether if they're conflicted, then it's a no-go, right? But most importantly is their experience, right? So the greater number of years that they practice in that area of specialty or subspecialty, right, then the higher probability that the court would give weight to their report and their evidence. Yeah.
Okay. We've got some questions in Slido, if you can look on the screen. So the top one is, how much can an expert witness charge for his services if engaged by a private lawyer to represent its clients?
Represent the client. Okay. So can I maybe invite Isaac to jump in on this one?
It really depends on the complexity and the type of specialty that is involved, and the number of issues that the expert needs to address. I've had experts for from 2,000 ringgit to 10,000 ringgit. So it really depends on the case and whether how much client is willing to pay. If I have to be honest about it.
Yeah. So if I can jump in there, right? To answer, I mean, over and above what Isaac has shared, right? I think the reality is this: for an expert, right? First and foremost, if they're not conflicted, right, and they can act on the matter, right? Our advice would be that you should, if you're not conflicted, get the lawyers to share the medical records with you, right? Share the issues with you. And the lawyers will have a limited set of issues that we will focus on, that we think is relevant, right? And then once you've seen all of that, you come back to the lawyers and you suggest, look, these are my fees for my expert report. Then it can range. It can be something as low as 3,000 ringgit. It can go as high as 8,000 ringgit. It depends on the volume of records that the consultant doctor has to review, right, and the issues at hand. You see, and don't forget, when it comes to experts, it's not just liability experts. That means the expert is talking about the issue of liability of the consultant or liability of the hospital. It also includes quantum experts, right? Rehabilitation experts, which tends to join with quantum experts, right? Yeah. So, is there a fixed scale? The answer is no, right? What the lawyers will do is share with you, right? So the expert or the potential expert has an opportunity to review the documents, look at the amount of work he or she has to do, right? And then suggest a proposed fee. Once that proposed fee has been suggested, the lawyers will then seek instructions whether they act for the doctor or act for the hospital, right? Will then get instructions from their clients, and then we move forward from there, right?
If I can jump in, Felix.
Oh yeah, please, yeah.
That I've had is that they will request for a copy of the documents. They will look at it, and then they will ask me, okay, I'm gonna spend about 8 hours to prepare my report. How much is that worth my time? That's one of the ways how the expert provide his fee quote in preparing an expert report. The same goes like, okay, if I go to court to give my evidence, which may take about half a day or 1 day, how much is my time worth? And so on and so forth. It applies to attending meetings, to study further document, etc.
Okay, there is another question on hospital and your opinion on getting expert witnesses to represent the hospital, and what's the role of the expert witness for the hospital? What is his scope?
Yeah. So if I can invite Joseph to jump in this one.
Yeah. Okay, for the hospital, for the doctors, as we all know, the expert will review the medical records and provide his independent view on whether the doctor was negligent or not. So as for the hospital, the expert will first of all review the medical records and look at whether there is negligence or shortfall by the nurses or by any of the employees of the hospital. So then the expert will tell us whether there is negligence on the part of the hospital or not. Yeah. So,
And also, it really also depends on um, what are the clinical issues for the case itself. If the case involves clinical issues which are directed towards the doctors, so to speak, who is another defendant, then perhaps there may not be a need for the hospital to appoint an expert witness. But if there are allegations, clinical allegations against the nurses, the medical officers, then perhaps, yes, the hospital may need to appoint an expert witness. It really depends on what are the allegations and the facts of the case. What is the...
Yeah, sorry, I had a call from the hospital just now.
Oh, I got muted. Sorry. Yeah. So just to echo what Joseph and Isaac said, right? The appointment by a private hospital of an expert is actually very fact sensitive. So just to echo what Isaac and Joe said, I mean, if it's purely clinical in nature, right, then the likelihood is, as lawyers for the hospital, we may not suggest the appointment of an expert. But at times, of course, if there is more than one consultant involved, right, and we need to get better clarity, right, on the factual circumstances and the issue of liability, if there is, right, we will then advise the hospital to appoint experts.
There's a question on what will happen if two experts were called, one by plaintiff, one by defendant, and they give opposing opinions.
Yeah, I'll jump in first and then I'll invite Isaac and Joe. Right? That's actually the usual cause of events, right? More often than not, right? As Isaac and Joe had shared earlier, look, if it's a clear-cut case of um, operating on the wrong knee or the wrong leg, that's a no-brainer. You don't need an expert, right? In a situation of an usual medical malpractice claim, right, the plaintiff will usually appoint an expert, right? Um, Likewise, the defendant, which may be the second defendant, which is the consultant doctor, and the hospital being the first defendant, the consultant doctor who treated the patient will appoint an expert, right? And you will have a position where, if, for example, if the consultant doctor's expert takes the view, right, that there is some shortcomings or negligence, right, or failure in standards by the consultant, right, that report will not be shared, right, will not be filed, right, and what the consultant's solicitors will do is seek to resolve the claim. Okay, in the event the expert report for the consultant is that it is defensible, right, then you will have an exchange of reports. The court will fix a date for exchange of expert reports, right? This is called the case management process. And then we go to trial. So you would, more often than not, in fact, 90% or more of our cases is such that you will have differing opinions by different experts. And that's the reality that's been going on for the longest of time. Yeah. So I mean, Isaac, Joe, please feel free to jump in if you want to add on to that.
No, Joe?
No, I don't have.
Yeah.
How would one know whether one's evidence has been?
Can an expert charge up to 10K? Should he not? Is that the one, Dr. Allen?
Yeah, I think there's another one about expert.
Well, as far as expert fees is concerned, we've answered it earlier, right? And the 13th schedule is fixed as far as the Private Healthcare Act is concerned, right? Vis-a-vis your treatment costs. Yes, I do know there's a reference, right? But by far and large, look, if I may just throw this in now, right? By far, what is actually happening as far as medical malpractice is concerned, right, in claims against consultants and hospitals, is there is an increase in the number of cases over the years, right? And it is important for doctors, right, in whatever specialty that you're in, to be prepared to offer yourself to undertake giving evidence as an expert. And that's important because what we see over the years, right, because we've been doing this for so long, that more and more doctors decline being an expert. We appreciate that the difficulties that you have because of your commitments, right, as a consultant in a private hospital, right. But what is important is, at the end of the day, more and more consultants, doctors in private practice need to consider, right, offering themselves as experts because there's so many cases. And there's a struggle for lawyers, whether it's the plaintiff always gets the first bite, the patient always gets the first bite. Because once we disclose the medical records to the patient, and that's what's called a discovery stage of just medical records, right? The patient then has the opportunity to go and shop for an expert, get an expert report, and that's what they do. That's what they do. We will share with you. That's what they do. They get an expert report, and then they file the claim. Okay. So they already have an expert from get-go. Whereas then, consultant is scrambling for an expert, right? And the hospital, if necessary to appoint an expert, is also scrambling for one. You see, so I would like to invite all of you on this webinar, right? Please consider offering yourself as experts.
I'd like to
Isaac, jump in. Yeah, by all means.
no,
Yeah.
no, no. I'd like to give my thanks to Tan Jin Hui. Well, the answer is you have to ask the lawyer who appointed you, but which reminds me that I need to also tell my expert that his evidence has been accepted by the court.
Tan Jin Hui, right? The answer is very simply that upon conclusion of the trial, right? What happens is, so that means there's a process, right? You know, the witnesses for the plaintiff patient give evidence, witnesses for the hospital give evidence, witnesses for the consultant doctor give evidence. If there's more than one consultant doctor, then all of them give evidence. Once that is concluded, then what the lawyers do for each of the parties is we prepare written submissions, we file written submissions, and then there are oral submissions. After that is concluded, then only the judge will then deliver his decision, right? And in delivering his decision, right, is when he will say what he accepts, and it is the reality of what we see, the three of us, is that at times judges, right, in dealing with expert evidence, will accept different portions of different experts' evidence. So they can accept, they take a certain point that the plaintiff's expert says, the patient's expert, a certain point that the consultant's expert says, and a certain point that maybe the hospital's expert, if the hospital adduces an expert evidence. And then he looks at the cross-examination and he takes what he wants to take, he or she being the judge, right? And then deliver a decision. So to give you a crystal clear answer as to whether it's been accepted in totality, forgive me and forgive us, we can't give that. At times, yes, it is accepted in totality. At times, the judge picks and chooses what evidence he thinks is relevant to his decision. So that's the answer to your question. Is there a possibility that the expert will attempt to sway the judge to the client's advantage? No. I mean, Isaac, you wanna jump in on this one? I mean, my answer is no, but yeah.
Okay, no. How to put it? If you are an expert witness in a case, you just remember that doesn't matter who appoints you, whether the plaintiff, the patient, or the defendants, the doctors, or the hospital. Your duty is only to the court. So just remind yourself that whatever you do, all you need to do is to give your candid and honest opinion on the matter. And if you go to court, just answer the question as honest as you can. And also, using whatever medical literature you have, how, to sway the judge to in favor of one party over another, that's for the lawyers to do. But insofar as an expert's responsibility is concerned, your duty is only to the court.
Joe, you want to jump in? You're okay with that?
Yeah. Correctly pointed out by Isaac that the independence is paramount. The duty of an expert is to the court. So when an expert reviews the medical records, he has to provide his independent views. He has to put himself in the shoes of the consultant, and what would he do in that scenario? So yeah, I have nothing to add.
Yeah, I mean, so let's add on to what Isaac and Joseph have shared, right? Yes, the expert is appointed by a particular solicitor for a particular client. Plaintiff's expert is appointed, right? I mean, the reality is this. The plaintiff's expert is there, right, to write a report, give evidence on errors, right, negligence, right, of the consultant doctor or hospital. The consultant's expert is there to defend the position of the consultant, right, in what he did, informed consent, right, procedure, surgery, etc. Right? And if the hospital appoints an expert, likewise, that's what the hospital's consultant will do. I mean, the expert will do, right? to defend the position. So you've got these two opposites, right? You've got the patient side plaintiff, right? And they want to nail the consultant in the hospital, and then you've got the consultant's expert and the hospital's expert trying to defend the position, right? The process is this, right? And this is something you need to understand. The judicial process is this. It goes through a full trial. Whether it's the plaintiff's expert, the consultant's expert, or the hospital's expert, they prepare the reports. The reports are filed in court well in advance of the trial. Okay. Next, if there's a position that any of the lawyers take that they want to file rebuttal reports, the court will consider. After that is the full trial proper, whether by virtual trial or physical trial in court, right? These experts will be cross-examined, whether for the plaintiff, for the consultant, for the hospital. They will be cross-examined, and that's the test. They will be cross-examined. The judge then makes a decision as to which expert report he prefers and why. It is a requirement of law, right, that he must state why he prefers a certain expert's report or his evidence. You see, so it's not just a process of we file reports and jalan and kautip. No, it is tested. Those expert reports for whichever party is tested in cross-examination by the lawyers acting either for the patient plaintiff, the hospital, or the consultant. You see? So there is the due process of law, right, that takes place. And that's a very important process. Yes, the experts will affirm and state that they owe their obligations to court. So the fact that, Felix Raj Chambers acts for a hospital on a claim or for a doctor on a claim, and then, we engage a consultant who is paid by us, that is known and accepted. Everybody knows that somebody is going to pay for the report, right? Somebody is going to pay, as Isaac says, somebody is going to pay for the expert's attendance in court, right? But the duty is on the judge at the end of the day to decide, once he hears all the evidence, right, depending on how the expert answers, right? Like what we have shared earlier in the presentation, for example, experts giving evidence which is not in their area of specialty, not in their area of subspecialty, right? Then they will be criticized by the court. You see? So the weight that is given to the evidence of those experts, regardless who they act for, will be determined by the judge based on the cross-examination. So it's a huge role that the lawyers play, whether for the patient, for the hospital, or for the consultant, right, in cross-examination. It's a massive role. It's a massive role that we play, right, in order to either, it's either we're criticizing the report, and how we cross-examine the experts, right? And that's where, at the same time, if we are going to cross-examine experts, we need the assistance of experts. Yeah. I hope we have answered that question.
The next question is about difficulty in getting expert witnesses because you don't like to testify against fellow colleagues. So how often is this situation and how does the court handle it?
Let me jump in, right? Yeah, it's difficult. It is difficult, right? Where consultant doctors don't want to comment or criticize a fellow consultant doctor, right? And remember this, what we said earlier, the patient always has an advantage. They will always file an application or they will send a letter first, right, asking for disclosure of the medical records, and that letter be sent to the hospital. Medical records, not medical reports. Medical reports, they will send to the consultants, right? Sometimes they send both medical records and medical reports to the hospital, right? Hospital deals with medical records, right? Treating consultant, whoever the treating consultant is, deals with medical reports, okay, right? They get all of this in advance, right? Depending on the circumstances, right? Based on case law, if the patient is not a minor, right, not deceased, right, and the patient is in a position to give consent for discovery or disclosure of their medical records, it will be disclosed by far and large voluntarily by the private hospital. Right? They get the records. They have their own panel of experts, more often than not, these plaintiff lawyers. Right? So they are ready to go. Like I said earlier, they're ready to go. Right? They'll only file the claim if their own experts tell them, this is the shortcoming, this is the error, this is the failure, right? Taking into account the relevant legal test, right, on negligence as far as consultants are concerned, right? Okay. Hospitals is still the Sunway case, Suching Ling for now, on vicarious liability and breach of non-delegable duty of care, right? Okay. Yes, for the consultant doctor or for the hospital, right? Yes, it's a struggle. It's a struggle, right? Because, like I said earlier, which is why I invited all of you who are attending this webinar, right? Offer yourselves, because there's a dearth of experts who are prepared to come forward. Yes, it may be your colleague, right? I mean, you have to make the decision. If you feel uncomfortable, right, then the best I can suggest to you, right, subject to what Isaac and Joe may say, is at least suggest to the lawyer who contacts you, whether for the consultant or the hospital, is there somebody else that we can contact? You see, if it's not within the private sector, we can always go to the government sector. No issue. You see, so help your fellow colleagues, right? Because don't forget, right? You never know when this is going to turn on you. 10,000 procedures, something is going to go wrong. Always remember this, right? You can be next in line. I'm sorry, I'm not trying to scare any one of you, right? But that's reality. Look at how busy your practices are. So just remember that. Yeah. Sorry, Isaac, Joe, if you guys want to jump in.
I think the query is more on how would the court handle it. Okay, like Felix has said, most of the times the ones having trouble to find experts would be the ones, the defending parties, the doctors and the hospital. So if there's a court action, what the court will do is that, okay, you have to file the expert report within 4 months from today. And within that 4 months or X months, we will try to find an expert. But if we cannot find, of course, we have to make a formal application to court. Please give us an extension of time. Time and again, we had to do this, but there's a limit to how much extension of time the court can give to file the expert report. If the court waits too long, then the court will just get, you know what, never mind, let's just proceed to the full trial without the expert report. So, and to echo what Felix has said earlier, we would be grateful in, if you could consider, offering yourself to provide your expert opinion if there's a request. Because in reality, especially for the doctor's side, we are short of experts.
Yeah, for me personally, we search for a particular expert in a particular area of specialty. I've searched for high and low from all the way from Penang to Johor. There's no expert available. I had to go all the way to Sarawak. I have to look for an expert in Sarawak for a particular. So what I'm trying to stress here is not only that doctors are not willing to come out to defend their own fellow colleagues, but the specialty itself is so niched that it's only less than 10 doctors who may practice in this particular specialty. So yeah, so when lawyers approach you to give expert opinion, please help us by helping your colleagues by offering yourself to to volunteer yourself to be an expert in a particular matter.
I mean, if I can jump in here, right? Look, doctors, right? The advancement in medicine, right? Whether it's treatment options, robotics, right? I don't know how AI is going to mess things up for you guys, right? It's advancing continuously, right? And what you have to understand, as Isaac and Joe shared in the slides earlier, is that a High Court judge or any judge, whether it's Sessions Court judge, High Court judge, most of these claims are in the High Court, right? Court of Appeal judges, which is a panel of 3 judges who hear an appeal. Federal Court, normally a panel of 3, can be on special request, can be a panel of 5, can be a panel of 9. Right? They are the judges and the lawyers, the 3 of us, right? As much experience as the 3 of us have handling medical malpractice, we will still seek and defer to whatever advice that an expert gives, right? So therefore, with the advancement of medicine, medication, treatment options, surgical options, robotics, it's so much, right? It's just growing by the day, right? That if, as lawyers acting on the defense side, right, we need your support. And I'll say this for all lawyers who act for doctors and for hospitals. We need your support. We need you all to come forth and say, look, fine, I will write. Even if, fine, I said earlier, the need to have some experience. But, this is always the chicken and egg, right? I want somebody with experience, right? To gain experience, you need to start, right? Yeah. So start. And it's fine. We have got enough. There are enough times that, the 3 of us have appointed experts who have never given evidence in court, right? So it's fine. But what I'm saying is, I'm inviting all of you, right? Consider, right, writing expert reports, right, for doctors who are, claims are filed against them as defendants and hospitals. I see Dr. Allen, I'm working with KKM.
Yeah.
Is that the next one?
Yes, there's one question from a KKM doctor. He gets subpoenaed, and whether they can refuse the subpoena if no one is paying for the travel
No,
costs.
you can't. If you refuse,
Not
right?
okay.
Okay.
To ignore. But
Yeah. Go ahead, Isaac.
sorry, if I'm not mistaken, the one who issued the subpoena is required to offer to pay some allowance for traveling and accommodation. However, if there's no such offer, you can ask. Don't be shy to ask. Okay, you can tell the lawyers, okay, I'm agreeable or I'm willing to attend court to give my evidence, but can you please pay for my traveling and accommodation costs? You can ask if there's no offer, but please do not ignore or refuse the subpoena. Please don't do that. You can get into a lot of legal trouble. Anyone, or maybe the next question?
Sorry. There's a pertinent question about experts, witnesses, expert opinions from doctors who have stopped performing surgeries or procedures for a long time, more than 10 years and 15 years, but they continue to provide expert opinions. What's the panel's opinion?
Okay, I will jump in first, right? Now, in providing expert evidence, I think it's a no-brainer, right? It's a no-brainer that the expert has to be in continuous practice, right? And has to be informed of, the latest procedures, right? Medication. I just said that, medication procedures, robotics playing a big role today, right? I don't know where AI is going to take all you guys to, right? So 15 years, right? Look, it's a no-brainer that any lawyer acting for the opposing party, right, is going to have a field day with that expert. It's going to have a field day. So if you are somebody who has ceased practice for 15 years, right, I would strongly suggest don't be an expert. The answer is this: absolutely no. I wouldn't appoint you anyway. Yeah.
But Felix, desperate times, desperate measures. So if if such an expert is available, and I have no other expert, then if the expert is appointed, provide his expert report and attends court, it goes. The opposing party might use his lack of field experience to bring down his credibility. So to echo what Felix has said, it's not recommended to agree to become an expert witness if you have been out of the field for 10 or 15 years.
Yeah.
There are quite a lot of questions remaining, so we probably have to move on. Maybe you want to pick the ones on the screen.
What is the last one, Doc?
We already exceeded time. Now
Okay.
it's about 12 minutes past the hour. So
If I can say, acceptable length of expert's report depends on facts and circumstances of the case and the review of the medical record, right? Should the doctor or the hospital insist on acquiring an expert witness? Okay, your legal counsel needs to seek advice from your panel solicitors, right? The doctor is always separately insured. A private hospital is separately insured, so you will get separate advice from your own insured panel solicitors. That means the insurers who appoint, right? Out of curiosity, why is it that defendant finding it difficult? Okay, like I said, like Isaac, Joe, and I shared earlier, the patient always has advantage because well before they file the claim, they get the medical records. They may get the medical reports of the treating consultants, whether it's a multidisciplinary team or not, and they get the expert report. That's the reality. The difficulty for the defendant, which is either primarily for the consultant, is because there are issues of conflict of interest, the issues that the consultant is too busy, there's no time to write, the issues that the consultant knows, right, the particular doctor, right? So there's a conflict of interest. So it's multiple. So that's the reality, which is why I'm inviting all of you, right, to jump in and write reports. Thank you for the early reply. My next question may be not related to being an expert witness. I'm not sure what the question is, Dr. Alan.
Maybe not so relevant. Let's stick to the expert witness. There's one interesting one from YouTube.
Yeah.
In your experience, is there any case where a judge will question the expert witness's experience? And will that affect the statement given?
Okay, I mean, I'll jump in first, right? Then Isaac and Joe can jump in. Look, the judge, right, being the presiding judge, right, he has a right to question the expert. He's not going to question the years of practice. They accept what it is, right? But he will question, right, what the expert says in his report, regardless who he acts for, right? And try to come to an understanding. Because remember, the judge has got this ultimate duty of listening to all the evidence, right, and coming to a decision as to which way he's going to go and why. He has to have a reasoned decision. He has to write it down. Right. So years of practice is not going to be critical, right? But as I said earlier, right, for you to gain your experience as far as an expert, you need to give expert evidence. But if you're looking at years of practice as a consultant in a specific field or a subspecialty, right, that again is not a key consideration. What is relevant is, right, in deciding on the expert witness experience, right, it is your ability, right, to undertake cross-examination. Remember, we said this earlier, cross-examination very relevant, because the patient plaintiff's expert, or rather his solicitors, will cross-examine you, and that can affect your evidence and your report. We have had enough occasions, Isaac, Joseph, and I, right, where the plaintiff's expert actually backs off. He says something in his expert report, then turns around and says, "Oh, no," in cross, that he's prepared to reconsider the position, and he changes his position. Likewise, for the expert, for the consultant doctor who's a defendant, or the hospital. Yeah. Joe, Isaac, you want to jump in? Yeah.
I'll just jump. Basically, normally when you prepare an expert report, we will exhibit your CV into the court. So we will tell the court the experience that you have and you've gained. So generally the court will not question the expert witness experience. Also in the CV, you will state how many years of practice you have been, and also you will state your background. So generally the answer is no.
And also, the length of one's experience is not the only factor that affects one's credibility as an expert witness. I mean, just because one has been a consultant anesthetist for 5 years doesn't disqualify him from giving an expert report or give evidence in court. The court will also look into whether that expert has a hands-on experience to the clinical issues at hand, and whether that expert is able to produce the relevant medical literatures to support his expert opinion. So it's not really a major concern, the years of experience. I mean, of course, the longer you are at the field, the better, but it's not the only factor that will be considered.
Okay, gentlemen, I think we have really exceeded time. It's been very engaging. I think lots of questions. I think we covered most of them. So sorry we can't cover everyone. So we will need to move on to the conclusion of this evening's webinar. There is some last minute change in the way you will claim your CPD point for watching, because I just found out the MMA has disabled QR code scanning for webinars. Gentlemen, I have to share with you, sorry, because abuse of QR codes, even amongst doctors, those who didn't watch, they go and share the QR code with other doctors who didn't watch. So this is quite unethical just to get that easily 1 point. Because of all this abuse, this convenient way of scoring the QR code has been temporarily disabled until another solution is formed. So please, before we end, if those of you who haven't subscribed to our channel, please do so, because we can't keep reminding you when our next webinar will be. So you let YouTube remind you. So hit the subscribe button, and that would help you stay tuned to our next webinars. So as a workaround to the claiming of CPD points, we'll have to do it through a registration form. So you have to go to your browser and type in dobbs.my/130923, today's date. Okay, this form will be valid until 12 midnight. So after 12 midnight, the form will not work. So if you watched the webinar, please use the form and submit the details there, and we'll have to manually upload your attendance to MMA. Okay, so sorry, there's no QR code. From tomorrow onwards, you don't have to do this. Once we have the MCQs, you can go to the forum and answer the MCQs to immediately get the point once you get the MCQs correct. So that's, I don't know, Felix, whether doctors, lawyers have to get CPD points, but this is what we have to do every year to get 20 points and in order to get our annual practicing certificate.
Well, doctor, right?
Yes.
I mean, not to say anything about my profession, right?
Mm.
I think Joseph and Isaac potentially tell me to shut up before I say anything. Right? Well, it happens. It happens to all professions. Right, Isaac? Joe, I made it general. Okay. But thank you so much for this opportunity.
Yes, gentlemen, thank you so much for this very engaging session. And I wish you all well. And thank you all, the audience, for your participation and your interesting questions. I think all of us learned something, and we benefited a lot from the session tonight. So, okay, Felix, Isaac, and Joseph, good night. And
Have a pleasant evening ahead. Thank you very much.
Yes, yeah. Thank you. And please fill up the form. We'll upload it tomorrow only after we get enough registrants.
Thank you, Doctor.